Hello all. This is another video on banking law. The questions here covered are endorsement, different kind of endorsements of checks, crossing of checks, law of dishonor of checks, release of contents of safety lockers. Coming to endorsement. Endorsement is the only mode of negotiation of note, bill or check payable to order. The very function of endorsement is to transfer the ownership of this instrument. This is discussed under the following headings like definition, kinds, rules and effects of endorsement. Coming to definition, section 15 of the Act defines endorsement. The act of a person who is a holder of a negotiable instrument in signing his or her name on the back of that instrument, thereby transferring title or ownership is an endorsement, and such person is called endorser, and for whom it is made is endorsee. The place of endorsement is also discussed in section 15. The requisites for of valid endorsement. The essentials for a valid endorsement are listed below. The endorsement must be done either on the back or face of the instrument, and if there is no space, then it will be made on a separate paper attached to it. The endorsement must be done in ink. Any endorsement done in pencil or rubber stamp is considered to be invalid. The stranger cannot endorse. It is necessary to be done by the maker or holder of the instrument. The endorser must sign it. It must be completed by the delivery of the instrument. The endorsement must be of the entire bill. The partial endorsement is not operated as a valid endorsement. Coming to kinds of endorsement. There are four kinds. There is endorsement in blank. When the endorser just signs his name, then the endorsement is called in blank. The endorsement does not show the name of the endorsee, with the effect that an instrument which is endorsed in blank becomes payable to the bearer even though originally payable to order, and no further endorsement is required for its negotiation. Example: if a check is payable to Jed or order and Jed merely signs on its back, such endorsement is known as endorsement in blank. Endorsement in full. If the endorser signs and also mention the name of the person to whom or to whose order the payment is to be made. Example: if a check is payable to Jed or order and Jed adds the words pay to X or pay to X or order, such endorsement is known as endorsement in full. Conditional endorsement. The conditional endorsement is dependent on the happening of a specified event, although such an event may or may never happen. That example, pay Jed if he returns from America. Thus, Jed will receive the payment only if he returns from America. If the event does not take place, the endorsee cannot sue any of the parties. Restrictive endorsement. In general, an endorsee is fully competent to negotiate in negotiable instruments. But Section 50 permits restrictive endorsement, which can easily take away the negotiability of such instruments. Illustration: if Jed endorses an instrument payable to the bearer as follows, the rights of X to further negotiate are excluded. That is, pay the contain to X only. Pay X for my use. Pay X or order for the account of Z. Like that. But the following endorsements are not restrictive endorsements. That is, pay X value in account of A back, because the endorser has not specifically restricted the negotiability of the instrument. Endorsement sans recourse. Sans recourse means without reference. When an endorser excludes his own liability in a negotiable instrument by express words in the endorsement, the endorser can insert a stipulation in his endorsement negotiating or limiting his ability. Illustration: pay Jet or order without recourse to me. Pay Jet or order sans recourse. Pay Jet or order at your own risk. These words will exclude the liability of the endorser altogether. Partial endorsement. It is defined under section 56, which explains that an instrument can't endorsed for a part or of its amount. If the endorsement is for rupees 200, it cannot be endorsed for 100 rupees only. But if the amount due has already been partly paid, a note to that effect may be endorsed on the instrument and it may then be negotiated for the balance. Coming to case laws, Muthireddy versus Pothireddy 1963, it was held that payment to the holder of instrument, which includes an endorsee for collection, provides a discharge to the maker of the promissory note. The right, which is based on the endorsement, survives even if the endorser dies and the endorsee could continue the suit, since the endorsement was made for a specific purpose, that is collection of amount. It will be valid that purpose is achieved. Moribund Finance Limited versus RBI. It was held that the effect of endorsement is that the legal title passes to the transferee and the transferee is then entitled to demand, receive or sue for money which is to be paid under that instrument. Law of dishonor of checks. It has come many times as case law also. Coming to introduction, according to section 6 of the Negotiable Instrument Act 1881, a check is a bill of exchange drawn on a specified banker and not expected to be payable otherwise than on demand, and it includes electronic image of a truncated check and check in the electronic form. There are six different type of checks and dishonor of check is of two kinds. Parties up to a check: drawer, drawee, payee, holder. Drawer is the maker of the check, that is who signs is the moral check. Drawee is the person thereby directed to pay, that is every time it is a bank. Payee, it is the person named in the instrument to whom or to whose order the money is by the instrument directed to be paid. Holder of the check means any person entitled in his own name to the possession thereof and to receive or recover the amount due thereon from the parties thereto. Coming to types of checks. Bearer check. A person holding the check can withdraw the amount only if it is signed. Such type of checks are very risky and in case misplaced can lead to loss of amount mentioned on the check. Crossed check. A bearer check becomes a crossed check by crossing it twice with two parallel lines on the left hand top corner. Only person name written on it can get the amount transferred to his account. Self-check. It is the name, as the name suggests, the account holder's name is written on it to encash money in physical form from the branch where he holds his account. Post-dated check. The post-dated checks are checks issued with a future date on it. Once a check is issued, it will be valid for 3 months. It is used for business purposes or making of the payment in a future date. Banker's check. Such checks are issued by the bank itself and guarantees a payment. Traveler's check. Such checks can be used for withdrawal of money while traveling. It is equal to carrying cash, but one can travel safely without carrying huge amount. They can be encashed abroad where foreign currency is normally acceptable. Coming to dishonor of check. A person suffers a lot if a check issued in his favor is dishonored due to insufficiency of funds in the account of the drawer of the check. To discourage such dishonor, it has been made an offense by an amendment of the Negotiable Instrument Act by the Banking, Public Financial Institution and Negotiable Instruments Laws Amendment Act 1988. Section 138 makes the dishonor of check an offense. The payee or holder in due course can have recourse against the drawer, who may be held liable for an offense. For the offense. Section 138. Section 138 discusses on dishonor of checks. It says where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or part of any debt or other liability is returned by the bank unpaid, either because the amount of the money standing to the credit of that account is insufficient to honor the check, that means insufficient funds in the account, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. Such person shall be deemed to have committed an offence, or shall, without prejudice to any other provision of this Act, be punished with imprisonment of a term that may exceed up to 2 years, or with fine which may extend to twice the amount of the check, or with both. Essentials for an action under Section 138 NIA 1881. There should be dishonor of check as per Section 138. Payment in discharge of debtor liability. The debtor or other liability in such a case means a legally enforceable debt or other liability. The presentment of check within the period of its validity should be there, that is, within 3 months of the period of validity. Dishonor due to insufficient funds, and dishonor may be caused because of two reasons. Either the amount of money present in the account is insufficient, or the amount to be paid has exceeded the amount to be paid from that account as in agreement made with that bank. Notice and demand from the drawer and drawer's failure to pay. Within 15 days of the receipt of the information from the bank about the dishonor of check, the payee or the holder must make a demand of the said amount from the drawer by giving a notice in writing. In spite of such notice, the drawer of the check should fail to make the payment of the said amount of money to the payee or the holder of the check within 15 days of the receipt of the said notice. When a banker can dishonor a check, payment countermanded by the drawer, that means it issues instructions to the bank not to make the payment. That means drawer makes an issues. Drawer issues the instruction or issues the instruction to the bank not to make the payment. Notice of drawer's death, notice of customer's insanity, notice of customer's insolvency and liquidation of the company. Liability of a drawer of a dishonored check. Civil liability and criminal liability. Civil liability, where a check is dishonored, the legal position of the drawer of the check becomes that of a principal debtor to the holder. The holder can bring civil suit just like any creditor to recover the amount from the drawer, making him liable as principal debtor. Criminal liability. A drawer of a check is deemed to have committed a criminal offence when the check drawn by him is dishonored by the drawee, that is bank, on account of insufficiency of funds. The criminal liability of the drawer in case of dishonor of check is dealt in Section 138 to 142 of Negotiable Instruments Act 1881. Case laws. Scenario after 2015 Amendment Act. As per this Amendment Act, a check dishonor case under Section 138, the case for dishonor of check is to be filed in the court of law as per provisions of sections 141 clause 1 and 142 clause 2, and even all pending check bouncing cases shall also get transferred to the courts as per this Amendment Act. This Amendment Act superseded the judgment of Supreme Court in the matter of Dashrath Rup Singh Rathod versus State of Maharashtra. In this case, a three-judge bench of the Supreme Court had held that a check bouncing case can be filed only in a court which has the territorial jurisdiction over the place where the check is dishonored by the bank on which it is drawn. Bridgestone India Private Limited versus Inderpal Singh. The check was presented at a bank of Indore where the petitioner, that is a company, resides and was subsequently dishonored. The respondent, that is Inderpal Singh, prayed to the court that Indore court had no jurisdiction to entertain this aforesaid proceeding, which was eventually accepted by the court applying Dashrath Rup Singh Rathod. But the Supreme Court held that Section 142(1)(a) gives jurisdiction to the Indore court to entertain the aforesaid proceedings, and the judgment rendered in Dashrath Rup Singh Rathod case shall not stand in any way of the petitioner. Coming to crossing of checks. This is dealt under the following headings: Introduction, crossing of check, need for crossing, eligibility for crossing, that means who can cross the check, types of crossing, and case laws. There are serious risks associated with payments to the wrong person. These risks can be avoided by giving the paying banker a clear direction about the person to whom the check is to be paid by specifying certain words on the check itself. This is crossing of check. Crossing is an instruction given to the paying banker to pay the amount of the check through a banker only and not directly to the person presenting it at the counter. The Negotiable Instruments Act 1881 sets out Section 123 to 131 the provisions concerning the crossing of checks. A crossed check is one in which two parallel lines on top left corner of the check are marked along with writing some particular words within those lines. The payment through these checks can be drawn only by the banker and thus are safer mode of transaction. A crossing is an instruction to the paying banker to pay the amount of check to a particular banker and not over the counter. The crossing of check ensures security and protection to the holder. Need for crossing. Why do you need a crossing of check? That is to minimize the risk. That is, crossing of the check gives paying banker instructions to pay the amount only through the banker and not directly to the payee or holder presenting the amount at the counter. It is an effective way to minimize the risk of loss or falsification. Paying instructions. Crossing is a way for the paying banker to generally pay the money to a bank or to a particular bank as applicable. Paying through the banker. Only a banker can secure the payment of a crossed check, which makes it easy for the holder to present it and with a quarter of respectability and credit that is known. The receiver of the amount. Only a banker ensures the payment of the crossed check, the money received can easily be traced for whose use it is given. Negotiability. Merely a check crossing does not affect its negotiability. Who can cross the check? In accordance with the Section 125 of Negotiable Instruments Act 1881, the following persons are authorized to cross the check apart from the drawer. That is, apart from the drawer. The holder. The holder of the check is authorized to cross a check either in general or in particular if the check is not crossed. The banker. The banker in whose favor a check is crossed in particular can also cross it in favor of another banker or his agent for collection purpose. Such a crossing is called special double crossing. Types of crossing. A crossing of check is basically two types, general crossing and special crossing. General crossing, Section 123 Negotiable Instrument Act 1881 deals with the general crossing. To transfer to transfer parallel lines across the face of the check is done if and C not negotiable or account payee are written, then it is general crossing. Special crossing is Section 124 which deals with special crossing. Two transverse lines are not required to be written in a special crossing. Mere writing a name of the bank across the face of the check constitutes special crossing. Double crossing. When the second banker acts as an agent to the first collecting banker, it is shown on the check by double crossing it. It is basically a type of special crossing which is done in the case where banker does not have a branch in the bank which is acting as a drawer. This is done in case where there is no banking facility at the place of paying banker. Not non-negotiable crossing. Section 130 of the Negotiable Instrument Act, which deals with non-negotiable crossing, states that a person taking a check crossed generally or specially, bearing in either case the words not negotiable, shall not have and shall not be capable of giving a better title to the check than that which a person from whom he took it had. In this case, the transferee does not get the rights of the holder in due course. Only if the title of the transferor is good, the title of the transferee is also good. Hence, in case of any taint in the title of any one of the endorser, the title of all the subsequent transferees are also become tainted. Illustration to understand this non-negotiable check. A in favor of B writes a crossed check without the words not negotiable on Allahabad Bank. C steals the check from the house B and endorses D, who makes it in good faith and value without knowledge of the theft. D will acquire a lawful title of the check. But if the crossing of such check was with the words not negotiable. Here, this title creates a material effect and this title will not be lawful. Case laws. Taylor Priya versus Gulab Chand. Calcutta High Court held the crossing of check not negotiable, however, does not render the check non-transferable. It only deprives the instrument of incident of negotiability. If the holder has a good title, he can transfer it with a good title. But if the transferor has a defective title, his transferee is affected by such defects and he cannot claim the rights of a holder in due course by proving that he purchased that instrument in good faith and value. Leduc versus Sheikh. In this case, now a not negotiable check was issued for wagering debts, that is, betting or gambling debts, and the holder could not enforce the payment. Bank locker and their rules. A bank locker is used for depositing valuables like gold, jewelry, and important documents. It can be hired by individuals, firms, trusts, companies, etc. The locker comes in different sizes like small, medium, large, and extra large. For accessing the locker, there are two keys. One key is with the bank, while the other key is with the customer. A locker can't be accessed without using both keys simultaneously. RBI rules and regulations on lockers are a bank can ask a locker hirer for an FD equivalent to the 3 years rent. Banks should try to provide locker facility keeping in mind commercial viability. A copy of agreement between bank and hirer to be given to the latter. Banks to carry out KYC checking of the hirer. This should be done for new as well as old customers not operating the locker. In this case, the bank has to notify the locker hirer to either operate the locker or surrender it even if the rent was paid already. For identifying owner of the keys, keys could be embossed with the bank or branch in identification code. All possible safeguards to be taken by bank for protection of bank locker. Laws followed by banks on nomination. Banks are supposed to make guidelines based on following laws. Section 45 ZC and 45 ZF of Banking Regulation Act 1949, Banking Compliance Rules 1985. This is also called Banking Nomination Rules. Indian Contract Act and Succession Act. Banking Nomination Rules 1985 says only single individual can be nominated. Nomination can be cancelled or changed during the period in which locker is under hire. In case of nomination of minor, another person to be authorized on behalf of a minor. Section 45 ZE of Banking Regulation Act 1949 says a person can be nominated by locker hirer who can give access to the locker and remove locker contents in the event of death of locker hirer. When a locker is hired jointly and can be operated jointly only if one of the locker hirer dies, then the nominee and the surviving joint hirer can access the locker and may remove its contents also. Before removing contents, an inventory of the locker contents should be prepared and signed by nominee or jointly by nominee and the surviving locker hirer. There is no liability of the bank after removal of locker contents by the nominee. Section 45 ZF of Banking Regulation Act says no person other than hirer or hirers can give a notice to a bank for claiming locker contents except that from a court of competent jurisdiction. In that case, bank should take note of such decree. Case laws. Mahinder Singh versus Punjab and Sindh Bank CPG. Complainant filed a case against the bank when he found out that the contents of the locker was taken out by the previous allotee. He found this out when he was unable to open his locker and with the key provided, and the locksmith ascertained that he had already broken the lock earlier. Bank officials also confirmed this. Bank in its reply told that it was a case of mistaken identity. Judgment was in complainant's favor as bank had completely failed to follow its own guidelines regarding locker operation. Also, banks are supposed to have a policy on forcibly opening of locker. Canara Bank versus Agnes Develop. Complainant went to the bank locker with her sister-in-law on 24 12th May 1987 and deposited jewelry in the locker and locked the locker. On 13 August 1987, manager of the bank informed her sister-in-law that locker was found open and jewelry was stolen. The complainant filed a case in state commission, which ruled in her favor and ordered the bank to compensate her. Bank filed an appeal before the National Commission. The Commission held that the bank which provides a locker should ensure the safety of locker. Commission contended that the bank has to pay liability to the complainant. Thank you. Please like, share, subscribe and comment.